up against a deadline on the other side. It's really my great pleasure to welcome you here today for the third annual Herbert Bernstein Memorial Lecture. This lecture honors a professor from Duke Law School who came in 1984. He died unexpectedly in 2001 and was really the voice of comparative law at Duke Law School for many years. He always he was the person to whom you went for all comparative law questions, and he was a steady voice for having more comparative law scholars on the faculty, a voice which we really didn't begin to take heed of until after his passing. I think he would really love to see the Duke Law School of today with Francesca Bignami and Ralph Michaels and even his own colleagues doing an increasing amount of comparative law work themselves. Deborah DeMott on comparative corporate governance, Jonathan Weiner on comparative approaches to environmental law, Neil Vidmar with his work on comparative juries, and so on. So it's really become a much richer place in comparative law than it was when he told us all of the many possibilities. This lecture is an example of that greater sense of seriousness of purpose about comparative law, and I'm just absolutely thrilled to see as many people recognize that importance as have turned out for us today. I want to put in a plug for an issue that came out in the past year that was a symposium published by the Duke Journal of Comparative and International Law in memory of Herbert Bernstein. It's a very good issue made up almost entirely of work by our own faculty, and there's some really quite excellent articles in it. Person who played a hand in that issue, as well as being one of our great comparative law scholars, and although he doesn't always accept that label, someone who's been here since 1981 and been a real leader in the international and comparative law area, will be introducing our speaker, Don Horowitz.
Thank you, Dean Bartlett. I should tell you before I introduce our speaker that there's an overflow room in 3037. If anybody would prefer to have a seat and see the proceedings by remote control, it's possible to do that in the next room. Herbert Bernstein was a dear friend and colleague of ours, and we're very particular about whom we invite to speak in his name. If I were to give you a fair sample of our speaker's accomplishments, it would consume the time he has to deliver his lecture, so I have to content myself with just a few things. Chibli Mallet has studied in Lebanon, in England, in Germany, in France, in Spain. Obviously, he had a lot of trouble keeping a student visa. And he also studied in the United States, where he received an LLM. Never mind that it was from Georgetown in 1983. I met him during his incarnation at the School of Oriental and African Studies at the University of London back in the early 90s and made a mental note to invite him to Duke. Well, I'm a little slow, what can I say? I should tell you that when he studied in England, he studied Shakespeare. And I have visions of his saying one day, alas, poor Horowitz, I knew him, Horatio. He has written widely about commercial law, about Islamic law, about America, about democracy, about the Iran-Iraq war, and he's also written a children's story. Most recently, he's published a two-part article which I commend to your attention, on the subject of Middle Eastern law, an article that challenges all the established categories, and you can find it in the American Journal of Comparative Law, the last issue for 2003 and the first of 2004. Professor Mallet occupies the Jean Monnet Chair in European Law at Universite Saint-Joseph in Beirut, and also, just on the side, happens to practice law in that city. It's a pleasure to introduce Chibli Mallet, who will speak on constitutions for the 21st century, Emerging Patterns, the European Union, Afghanistan, and Iraq.
Well, just a few minutes of Southern hospitality yesterday with Dean Bartlett, today with this charming introduction, tells you how you make mistakes in your life when you choose law schools to go to. I am most honored to be here. Professor Bernstein, I remember having read some of his articles a long time ago. I have been long an admirer of Heinrich Kurz, whom you invited to give the first lecture 2 years ago. I'm really delighted and privileged to be amongst you today on a topic which seems far-fetched in terms of a comparative exercise, but the choice of this has been a challenge for me from the day I received the invitation from Dean Bartlett. And I hope that there will be some coherence to this exercise in comparative law at a level which is both, I presume, challenging and particularly difficult. The lecture will consist in 3 parts, really, where I will be trying with you to explore what the emerging patterns for constitutionalism in the 21st century appear to bring us with them along very difficult paths in the 3 constitutions which have, with great difficulty, been emerging over the past year in very different parts of the globe. And by way of introduction, which would be the first section, the main concept that I would like to put to you is about the international drive of constitutionalism as we see it developing before our eyes. Amongst the furthest encompassing contemporary reflections on law stand the works of Paul Kahn. In a contribution to a Latin American New England seminar on law and violence in 2003, he had this to say about the EU. The political project of the EU, for example, is about displacing a sacrificial politics with a set of bureaucratic arrangements for the administration of markets and social welfare. If the romantic element in Western politics has been in its attachment to sacrifice of the body, the EU project is just the opposite. It is politics as management of the well-being of the body. The bureaucrat in Brussels is the very opposite of the romantic politician. The longing to join the EU among the countries of Eastern Europe is not just about economics, but also about depoliticalization, i.e., about an emerging perception of sacrificial politics as a form of pathology. Indeed, the entire effort of the international human rights movement is rooted in this vision of well-being. No one in this view should die or suffer for politics. End of quote. There are several strands in the Kahnian view which will appear elusive for those who have not followed his fertile search for the triangle love, law, religion, and the meanings relevant to the triangle for such issues as war and international relations, the body, or human rights. In a vision which tends to be overall bleak, the silver lining is a peculiar form of legal optimism which is of significance to us today. Here we need to bifurcate. One bifurcation regards the EU and constitution making, the other is Kantian and regards constitutions and war. Strong moments in constitution making often result from traumas, sacrificial politics, amongst which the archetype is Abraham's offer to sacrifice his son for God in order to save his people, religion, and nation. The case of the EU, which is universally considered as a triumph of Europe over its 20th century most tragic traumas, Two World War for the Europe of 6, the Cold War for the Europe of the 25 to 30, is a living, acknowledged example of this sacrificial politics, this trauma. Afghanistan and Iraq, another. Nothing defines trauma for Afghanis and Iraqis more than war, internal and international, for over a quarter of a century, and their most lasting response, if war is to be transcended, will be a working constitution. Here is the contribution of Paul Kahn at its best, 21st century constitution making, conceived as a response to the failures of the 20th century, and a new prism, the love, religion, law triangle, to go beyond comparing the trite and the insignificant, or the incomparable, or the hard to compare. We are embarking this morning on a similar quest. Rather than look at these three perforce unique constitutions simply through black letter law, we shall try to transcend the immediate arrangements of the respective constitutional texts in search of emerging patterns of constitution making this century. Here is then the constitutional bifurcation, which we start examining through the more central signifiers in each of the three constitutions. But briefly first of the Kantian bifurcation, which is not unrelated, but which is the subject of separate work in progress. As Kant also says, after Einstein, we are all Kantians. And no person has written a more meaningful treatise on war, constitutional treatises, and international law than Immanuel Kant. This year, on the occasion of the bicentenary of Kant's death, the Goethe Institute has been particularly inspired in its depiction of 2004 zeitgeist through the poster which puts, on the one side, the 300 plus wars that have befallen mankind since 1804, on the other, the poster, the text of Kant's treatise for perpetual peace. So this is separate work in progress on Kant's Zum ewigen Frieden, but it cannot be totally shorn from our present reflection, so much steeped in war, those societies working out these constitutional texts, and so menacing to both domestic and international peace if they fail their promise. Should Iraq, Afghanistan, and the EU roll their constitutions back, for whatever reason, much of the promise of peace would fall by the wayside. In Europe, the new constitutional order was designed by Jean Monnet to prevent a repeat of World Wars I and II, both classic wars. The collapse of the Afghani and Iraqi theaters of violence in the so-called war on terrorism, a sui generis development increasingly dubbed as the Third or Fourth World War, will have incalculable consequences, first for the peoples of Iraq and Afghanistan, but also for the rest of the planet. So while the Kantian bifurcation would appear at first glance to stand outside the pale of our present research, we can see how it suffuses it throughout. Already, the inside-outside image of constitution is breaking at the seams. Constitutions constitute traditionally eminently sovereign texts made by people to rule themselves by themselves. This is no longer the case. The fiction of a self-organized Iraqi constitution or of a self-organized Afghani constitution might be naturally peddled by the Iraqi and Afghani governments. Few believe their constitutional input and output is not international. As for the EU, even a fiction encompassing the 15 member states, or indeed the additional 12 delegations from the enlarged continent attending the Constitutional Convention, makes the effort by nature a particularly non-national one. More importantly, the international drive of EU constitutionalism is now formally enshrined in the EU's proximity policy. This is not only about Turkey. The most intriguing, perhaps the most interesting article in the European Constitution in terms of emerging patterns, read here challenges for the 21st century, appears in Part 1, Title 8 of the text. It's entitled The Union and Its Neighbors. And it says, the Union shall develop a special relationship with neighboring states, aiming to establish an area of prosperity and good neighborliness founded on the values of the Union and characterized by close and peaceful relations based on cooperation. Much much has been built on this seemingly innocuous article on different levels. On the political plane, a full and daring proximity policy was announced and followed through from a European perspective by the former head of the Commission, Professor Romano Prodi. This policy suggests including any willing neighboring state in the EU system except for the EU's institutions. Short of voting and being represented in Brussels, everything else, quote unquote, could be common European for Prodi. On the academic plane, we have tried to develop this concept as a solution to the Arab-Israeli problem by way of a Hegelian-style Aufhebung resting on the freedom of circulation and establishment through the new immense territory constituted by the EU plus its Mediterranean neighborhood. So the EU as solution to the 100-year conflict over Palestine is one striking illustration of constitutionalism in the 21st century. The right to return for Palestinians would find its application in their freedom of movement over the new EU territory that includes Israel. For Israel, the fear of a destabilizing influx would be tempered by its opening up to European space, where part of its security would be naturally one shared with the EU. Now, this is a long shot, a generation at least away. But we're talking of emerging patterns for the century, and one can see how the EU has now internalized in this revolutionary text that pattern of constitutional internationalization. While it sounds excessive to think of it in such grandiloquent terms as the chance of a peaceful Mediterranean, or specifically a solution to the Arab-Israeli conflict, much in the manner that Europe has, quote-unquote, solved the Northern Ireland problem, we are contemplating here the promise of a century and not just of a few years. And while we were mentioning the Good Friday Agreement with its own constitutional peculiarities, one should reflect upon the dismemberment of sovereignties, which could hardly be conceived outside the framework of the concept of regionalization and the hankering for a reality to the matter of subsidiarity across Europe and within its regions, the well-established as well as the contentious ones. So much for constitutionalism's international drive. Let us take a step back and indulge in a few simplifiers. By simplifiers, I mean those trusted mileposts which are the basics of constitutional making and which any drafter needs to contemplate in accordance with the received vision, which is essentially an 18th century legacy of political science and constitutionalism, more specifically a Montesquieu one. This is the concept of separation of powers, or the checks and balances in American law, coupled with the concept of federalism to accommodate regional disparities. Such vertical and horizontal division of powers is the stuff of any constitution making, arguably since Plato and Aristotle, and it goes along a number of classical questions from both sides of society. Seen from the top, how solid and impermeable are the boundaries between powers in the state? This, reduced to its simplest expression, raises the choice between a presidential and legislative constitution and the choice between a federal system and a centralized one. What are the powers of federated states? And if there are no federated states, how is power devolved and exercised by regional entities? Seen from the bottom, what voting power does the citizen have as individual and as member of a collectivity? What recourse does the individual have in case of infringement upon his or her rights as enshrined in the constitutional text? Now, even simplifiers can make life complicated when comparisons are exercised in dual terms, let alone when three nascent constitutions are being compared. National systems of law, the first-year law student learns quickly, are self-sufficient. In a fiction which is essential to understanding its realm, law operates outside history as well as outside geography. Legal history might explain much. It operates in a way irrelevant to the substance or content provided by a given statute. Comparative law is an additional luxury. Use of comparative law may be edifying, enlightening, or enriching, even persuasive. It is never dispositive. Yes, there are increasing exceptions in global law, even in the US Supreme Court. But legal history as comparative law and comparative law remain luxuries. The law stands for what it disposes, hic et nunc, not for how it came about or how it compares to beyond the realm of the jurisdiction in which it holds sway. So let us look from the vantage point of simplifiers at the overall architectonics of our three constitutions, each as a self-contained arrangement. Starting with the simplest, the Constitution of the Islamic Republic of Afghanistan as defined in its Article 1. Simplest because it now at least has been adopted, the other two remaining transient. Simplest because it is an essentially presidential constitution with a person, Hamid Karzai, in mind, drawing the constitution and implementing it. Simplest because there is no federalism in the text. Simplest because, despite the international convulsions in the modern history of Afghanistan, the non-Afghani input, unlike for Iraq and the EU, was limited. Simplest, finally, because there doesn't seem to have been too much work behind it. By contrast, the emergence of the Iranian Constitution in 1979 has left constitutional scholars a formidable trail of constituents' minutes. Composed of a preamble and 160 articles and divided into 12 neat chapters, the Afghani Constitution was written in Pashto and Dari, two of the several languages recognized in its Article 16. Following a familiar and didactic terrain, the Constitution presents the main attributes of the state of Afghanistan in the preamble and first chapter: flag, languages, religion, economic traits, and state responsibility for citizens' welfare, education, place in the international order, followed by the citizens' fundamental rights in Chapter 2. The organs of the state cover Chapters 3 to 8, presidency, government, national assembly, so-called Loya Khirga, judiciary, administrative divisions, then special dispositions are enshrined in the last fourth chapter, including the state of emergency and the amendment process. Most significant in terms of separation of powers is the establishment of Afghanistan as a centralized presidential republic where the head of the executive is elected directly by popular suffrage if he or she gets over 50% of the vote. The two candidates with the highest vote in the first term, as in the French system, fight it out in a second term, and no one can be elected as president for more than 2 terms. The president is extremely powerful under the Afghani constitution. As he heads the cabinet, there is no prime ministership. The list of presidential prerogative is long and wide-ranging, to which should be added the prerogatives of a government which cannot be brought down before parliament under a vote of confidence except for individual ministers. The president is even entitled to name of some of the members of the upper house, so-called the elders' house, in Dari, which is a variation on Persian. Parliament under the constitution is composed of 2 houses, to which should be added the Loya Khirga, originally a congregation of tribal leaders in which the constitution vests some historical mantle of sovereignty. In reality, the Loya Khirga consists of all the parliamentarians, to which are added provincial and district council heads and the members of government. And it's supposed to deal with the supreme interest of the country, but it is again the president who is entitled to convene it. Presumably, the Loya Khirga can in some cases meet of its own accord, since it's also entitled to pass judgment on the president in case he dramatically fails his duty, such as being responsible for crimes against humanity under Articles 110 to 15. Now, Loya Khirga and crimes against humanity, which appears in several articles of the Afghan constitution, may be for the comparative lawyer the most original concepts in the text. But the bottom line is about centralized presidential power, where the battle will be fought for the foreseeable future, for Afghanistan as well as for Iraq, and to an extent which we need to dwell also upon in the EU. The place of the president as chief executive rallying the country is the more important locus of constitutional attention, since the Afghani and Iraqi experience, despite sharing common international inputs, underline the difficulty of agreeing on the place of the head of the executive branch in accordance with the Montesquieu scheme of things. In Afghanistan, as the text stands, the president trumps the rest of the constitutional arrangements, be they central or federal. This may be unwise, especially since the incumbent owes his position to being the smallest common denominator picked by the United Nations. The battle for executive power will continue to define constitution making in the 21st century, as it has from time immemorial. That is certain. Whether it is wise is a different matter. Now, Iraq. In Iraq, the battle for the presidency has taken a different shape, despite a similar international input, including the same UN envoy. It played itself out differently, and the idiosyncrasies of history got the upper hand on planning. Poor Iraqis, trying to find some peace after 35 years of solid dictatorship, including the longest Middle East war in 20th century history, 2 or 3 invasions, that is their invasion of others and others invading them, plus a 12-year sanctions regime followed by occupation. In the midst of which mayhem, they put together a wonderful new constitution, according to the New York Times. It's true that the Iraqis who forge ahead with the constitution against the odds deserve a burst of enthusiastic kudos, but one should perhaps remain reserved on such elusive matters for fear of rapid ridicule by reality. Mugged by reality is increasingly a fashionable term. In the midst of so much violence, how did they do it in Iraq? They here are an unfortunate, though talented duo. One must realize what constitution writing means in Iraq 2004, and it means a lot of English, not only because a UN security resolution had consecrated a governor of Iraq who is solely American English speaking, and so wields the ultimate signature upon any text Iraqis may want to turn into law, but more fundamentally because the legal and judicial body of Iraq is simply inexistent. It is unfortunately as tragic as it sounds. So destructive of any judicial independence has the rule of the former Iraqi dictator been that Iraqi jurists who remained in Iraq simply lost confidence in their jobs and themselves. Not that there are no talents, dedication, or competence. Chapters of judicial and legal resistance in dictatorship Iraq are yet to be written. But there's no confidence doubling up with English as lingua franca, with polyglotism, being traditionally in Iraq a mark of treason for dark fascist Arabism. The systematic destruction of Iraqi legal cultures, its lawyers, judges, and law schools meant that constitution drafting was left to those coming from the outside. There simply aren't so many people capable of writing up a constitution in English words, which are also Arabic and occasionally Kurdish. So hail to the two drafters and their advisors. Friendship being involved here on both the drafting side and the advising side, all shall remain nameless for the time being. The result was a longish text with a didactic effort, 62 articles in 9 parts. We are still not in a phase of final constitution, and the transitional administrative law, as it is known, should self-erase when the elections planned for January 2005 result in a parliament which is tasked with writing the ultimate text and putting it to the vote. Meanwhile, however, some constitutional landmarks have been posted for Iraq. While buffeted by barbaric violence on a scale which knows few such precedents on the planet, the process is moving slowly forward. 3 matters draw the constitutional reader's attention. The first is the place reserved for women, who are to constitute a quarter of parliament. The second is the open reference to federalism. The third is the care given to the protection of the individual's right. If Iraq wishes to remain at the forefront of Middle East democracy, which you might be surprised to hear, I think it is, despite it being smothered by violence, both in terms of the freedoms it carries and the fact that those in power owe it neither to dynasty nor to the Middle East dominant self-extension of presidential mandates, then Iraq needs to protect these 2 achievements, women representation and federalism. This will not be easy. As for the judicial protection of the person's basic rights, it should come naturally if Iraqi society overcomes the violence that plagues it, while confirming its capacity to stand on its 2 feet without foreign armies dictating the terms of social peace. Now, much of this commentary is arguably hypothetical, but the morass of Iraqi politics should not mask the forest for the trees. In Iraq, constitutionalism is forging ahead in the most delicate of all arrangements, that is, the attempt for a constitution to be inclusive of 2 dominant and competing national identities, Kurdish and Arab, and 2 dominant and competing religious sects, Shi'i and Sunni Islam. Even under the most elaborate constitutional scheme, which Professor Horowitz has dissected in so many different approaches over 3 decades of scholarly attention to discrete and insular minorities across the world, one would find it difficult to draw a model near enough to accommodate the Iraqi socio-historical setup. Nor have the Iraqi constituents succeeded yet in convincing their people and the world at large that they are out of the woods. Now the EU. The Constitution, finally agreed by the European Council of Heads of State meeting in Dublin in June 2004, stands outside any recognizable model in the field. This, for obvious reasons, owing to the history of European integration. But it also stands out for technical reasons obtaining from its fissiparous genesis. The Constitution simply makes no sense for its reader outside the accumulation of texts since the 6 European member states came together on the so-called Common Market in Rome in 1957. This accumulation of treaties and of legislative, judicial, and administrative acts is known as acquis communautaire. In our appreciation of constitution making, it would not be appropriate to mark solely progress. There are also setbacks. One certain failure in the EU text concerns its style. However hard the constituents tried to make the text of the Constitution palatable to the educated but non-specialist reader, this effort must be acknowledged as a failure. Valéry Giscard d'Estaing, the head of the convention which drafted the text, even discourages in a preface reading part 3 of the text, which is the longest and most details, and The Economist rightly ran a cover page when the constitutional text was disclosed, suggesting to bin it. Could it have been otherwise? It's true that one distinguished former Minister of Justice in France did write in 2002 a model constitution which had the advantage of being short and more palatable, including actually most of the provisions which found their way to the text. This is Robert Badinter. So it could have been possible to do better. Yet there is no point in trying to rewrite history, and there are already a number of reader-friendly editions and short commentaries, of which the introduction of Giscard and a que by Professor Christian Philippe from Lyon stand their ground in terms of clarity and comprehensiveness. One problem is the type of consolidatory treaty which needs to integrate previous texts and the mechanism in the Convention which, for sake of including the largest number of proposals, failed to devote a stylistic effort which could have brought together the text in the US concise style. It's also true that the US Constitution is a unique text in the excellence of its constitutional style, hardly matched elsewhere on the planet. The EU Constitution consists of 4 parts and a number of protocols, of which 2 are important. Starting with the end, a brief 4th part deals with amendments and transitional measures. A 3rd part consolidates all previous treaties and is therefore the longest and most verbose. The 2nd part integrates the Bill of Rights, known as the European Union Charter for Fundamental Rights, approved in Nice 4 years ago. The 1st part is the most novel one, on which we shall mostly dwell to discern the possible trends in 21st constitutional making at the prism of the EU. Let me suggest, for the sake of argument, to follow an extreme critical line that follows from the universally acknowledged democratic deficit in Europe. Managing the 25 to 27 strong EU by 2009 does create in and by itself problems which have been dealt with in the EU Constitution as it could best. The creation of enhanced cooperation, which allows a group of EU countries to go forward with further integration without being hampered by slow or reluctant member states. The case of the euro is the most successful application, which does not include, as you know, Britain and Sweden. Already the EU operates on a system of a geometry variable, and this is fine as long as it does not burst at the seams. Even bursting at the seams has already been envisaged and happily dealt with when Austria found itself in the throes of a government dominated by racist extremism. From that emerged a freezing out procedure, which is also fine. Of course, should one country turn so undemocratic as to threaten not only being frozen out of the EU, but also engage in military hostilities against it, the issue would indeed be unprecedented. But even a major country or two turning in this nasty way at the same time would, in my view, not unravel the system. It might actually be a privileged way to consolidate it. Finally, the risk is for new countries to bring in their weak democratic system of deliberation, as would be the case of Romania or the republics of former Yugoslavia. But the remarkable democratic strides of Turkey to bring its legal system, both in terms of its books and more importantly in the application of its laws, up to EU standards, are testimony to the immense leverage at the disposal of the EU for countries far smaller than Turkey. Indeed, the annual reports that the Commission prepares on Turkish alignment with EU legal and economic standards may be one of the most innovative tools for the spread of democracy, human rights, and the rule of law across the world since the collapse of the Soviet system. No, the problem of EU democratic deficit does not lie in its expansion, and we should argue actually the exact opposite, namely that the world EU fashion, and more specifically the Middle East EU fashion, is a unique opportunity allowed by the emergence of unified Europe. No, the problem of the EU democratic deficit has been building up since the Treaty of Rome, and that problem is eminently constitutional, more specifically one of separation of powers. In 18 months of deliberation, the EU Constitutional Convention just failed to address it successfully. This problem is eminently Montesquieuian and results from the vesting of legislative and executive powers in a strange EU mixture of a triangle Council, Commission, Parliament, in which the two first institutions, the Council and the Commission, are dominant. Those, in contrast, who are elected Europeanly, that is, the EU MPs, represent at best a fifth wheel in the carriage, as the French motto has it. You can take most of the EU Parliament away, the maximum you will lose is a faint forum for deliberation and an even fainter one in terms of legislation. While the legislative process has been time and again redrawn at the margin in order to enhance its powers, any person familiar with the institutional work of the EU knows that Parliament is a place for occasional protest, not a power that anyone seriously takes into account. Now, the Council, being composed of governments who are representative of their people, is indispensable. It is indispensable because it does represent the people within the member states and brings into the federal European model the voice of the constituent peoples. The Council is also indispensable because even if it didn't contribute that federal voice, one can hardly imagine how laws enacted by the Union could be binding within each country in that ever wider field of European competence if implementation were not carried by the Council's governments at home. How about the Commission? Well, the Commission has real power, and that is the problem. But the Commission has no popular legitimacy since its members are appointed by the Council to play a European role. The Constitution has managed to establish a number of new high positions, including a president for the Council who will now fight it over with the president of the Commission head, much as the High Representative for the Common Foreign Policy and Security has already fought it out with the Commissioner in charge of Foreign Affairs, a sorry sight indeed. The result, inevitably, is more muddle, and with poor legitimacy at that for the new bicephalous institutions. None of these positions will be filled by direct popular vote. None will have serious legitimacy. No, the only serious step to bring democracy to Europe would have been to scrap the Commission and to give Parliament a real legislative role. One would still remain in the throes of the federal problem, but the democratic deficit would have been tackled head-on in a way that makes it meaningful to vote for a European MP. It is now, alas, mostly a waste of time, and the electors are far more savvy than the cooks of institutional Europe imagine. They simply do not bother. To underline further the democratic deficit in the EU version of separation of power, an error in the text is telling. No doubt attentive to the subdued role of Parliament, the constituents entrusted EU MPs, as the text goes, with electing the President of the Commission. This is Article 120. This article is further detailed under Article 127 on the President of the European Commission. I quote, taking into account the elections to the European Parliament and after having held the appropriate consultations, the European Council, deciding by qualified majority, shall propose to the European Parliament a candidate for the President of the Commission. This candidate shall be elected by the European Parliament by a majority of its members. If he or she does not obtain the required majority, the European Council, acting by a qualified majority, shall within 1 month propose a new candidate who shall be elected by the European Parliament following the same procedure. End of quote. A strange concept of an election indeed, in which there is no contest. Behind the awkward wording stands a battle for legitimacy on the European level for the head of its executive, be he or she President of the Council or the President of the Commission. Which president is a good question. one can imagine in a few years the confusion about the presidency, much in the way the confusion over who is Mr. Foreign Policy today, the commissioner in charge, or the council's high representative, or indeed the president of the commission. Maybe the ruse of the constituents was deliberate, as some comments suggest that an ideal situation, which is purposefully left open by the convention, is to see the president of the council and the president of the commission as one and the same. Nothing bars such a possibility in the text, but let us imagine they were. Both positions would continue to depend on a choice exercised by the council, and the commission's presidents. False elections by parliament would therefore be glaringly exposed. So back to basics of the democratic deficit. The constituents in Europe were unable to see boldly enough into the strange system of separation of powers they were perpetuating since the Treaty of Rome. They tinkered with it by establishing a president of the council who would conceivably stay in his or her position 5 years instead of the current rotation of 6 months, which was made impossible by the enlargement. They also tinkered with the presidency of the commission by suggesting the person in charge would be elected by parliament, whereas the candidate, only one, is nominated by the council. This leaves little democratic legitimacy to both executive and legislative powers in Europe, if indeed we mean by legitimacy the choice by the people carried out in the voting booth. Both the president of the council and of the commission are nominated by the council. In the case of the council's president, the parliamentary representatives of European voters have no say. In the case of the commission's president, parliamentary function is at best perfunctory, despite the constitutional language intimating his election, quote unquote, by parliament. And to top it all, parliament in Europe does not legislate. Now to my third and before final section. In our search for emerging patterns in 21st century constitutionalism, I would like to introduce another concept which has been of assistance in writing on family and gender issues, what I call acid tests. Acid is a metaphor which conjures up for different people and different cultures so many different images. One image, at least in my Western life generation, is that of a powerful mind distorter which clouds one's miserable life with a worldly vision induced by hallucinogenic drugs. For Iraqis emerging from 35 years of dictatorship, acid is a far more material reality as the most harrowing method of torture used by the former regime, said to be a specialty of the older son, which consists in lowering the victim on a pulley into a basin of acid, first the toes, and then draw back the pulley up and down repeatedly. One shudders at the image, and we should leave it at that. What the small Oxford English Dictionary says about acid tests is that they are severe and conclusive. In Iraqi context, one has no doubt they are conclusive. In all cases, acid tests are certainly severe, the more severe as they include faith-based and for all intents and purposes, quote-unquote, irrational convictions. I've chosen to pursue with you two such acid tests, that is, a number of legal constitutionals no-go or difficult-to-go areas which bring people literally up in arms. Religion in law is one, federalism is the second, to which is added the perennial issue of who is to be master, that is the presidency. So 3 acid tests. Religion in law first. Maybe the most trying of all acid tests is about the place of religion in the Constitution. The law and religion complex operates as acid test not merely in an Eastern Muslim context. It was and continues to be a central point of disagreement in European constitution making. For those who have followed that particular aspect of the debate, suffice to see the discrepancy between the German and French text in the translation of the preamble to the Charter of Fundamental Rights, a discrepancy which is in constitution writing, I think, unprecedented. While the French, as you know, text acknowledges the spiritual tradition in Europe, the German render it as a religious one. The constituents, and it is remarkable that it was the Irish who succeeded in preventing the acid test from blocking the whole process, finally produced a version which leaned towards the French disposition, much to the dislike and vocal protest of the Vatican, and skipping the mention of Christianity altogether from the text. Now, how does one deal with such a difficult test, religion of the land, in a constitution? Of tons of ink spilled on matters constitutional, one would venture this is the issue of unique portent in the United States as well as in Europe and the Middle East, bringing religious affiliation in the domestic context from born-again Bible belts to international clashes of civilizations defined religiously. That concern and the ink spilled is not about to abate. To make some progress in the shape of religion in 21st century constitutionalism, please allow me a literary detour. It may be a quasi-universal law of individual psychology, much in the vein of Sigmund Freud's Oedipus complex, that adolescence generally, and if not a later age, raises a form of religious libido in each and every individual on earth. Of that experience, two formulas I retain. The first is by Bertolt Brecht, whose alluring, the not likable character, Mr. K, was once asked about whether there was a God. Herr K answered, I would advise you to think whether your behavior, depending on the answer to this question, would change. If it would not change, then perhaps we can leave that question. If it would change, then at least I could tell you and be perhaps helpful and say that you've already decided you really need a God. That adolescent part of the argument fits well with a rigid view of separation between church and state and can be comforted with all kinds of citations, including from the most canonic sources, to wit, the words of Christ to the effect of keeping to Caesar what is Caesar's, or the lapidary injunction in the Quran about, quote unquote, no compulsion in religion. As one makes his peace with God or religion on this basis, acknowledging in the process that there is more to it than Brechtian need or Quranic rejection of state force to deal with one's professed faith, another citation sticks in mind, that of the Levantine poet's admonition of his children about the penumbra of dignity that the religion brings to the believers. Advising them, he says, do never be attached dramatically to a religion. All such attachment is recipe for disaster. Each one has his religion, and each religion has a perimeter of dignity which does not tolerate being challenged. This is, I would suggest, more subtle than Brecht because of the consideration of one's religion as shield and not as sword, to borrow a distinction from English contract law. Lord Denning, as you know, used it for promissory estoppel in the famous Central London Property Trust, High Trees House Limited case of 1947. The positive use of religion to shape the state is one thing. The defense of religion against aggression and other humiliations as such is another. In our respective constitution, this is generally the position adopted by all three constituents. The state or group of states is not so much neutral about religion, which is the classical position of a rigid doctrine of state and religion separation, as it acknowledges a heritage which in the case of Europe would include churches which thus receive constitutional recognition, as you can find in Article 152, or in the Afghan Constitution in Article 17, for the improvement of mosques, madrasas, and religious center. And in the case of Iraq and Afghanistan, a role for Islam which is not overtly militant. Here, Islam is to be perceived as a shield and not as a sword. The formulation in both the Iraqi and Afghani constitution is alluring. In the first case, Article 3 says that no amendment to this law may be made to affect Islam. Article 7 is equally protective. Islam is the official religion of the state and is to be considered the source of legislation. No law that contradicts the universally agreed tenets of Islam, the principles of democracy, or the rights cited in Chapter 2 of this law, which are the fundamental rights, may be enacted during the transitional period. This law respects the Islamic identity of the majority of the Iraqi people and guarantees the full religious rights of all individuals to freedom of religious belief and practice. In Afghanistan, the formulation is similar. Quote, no law can be contrary to the sacred religion of Islam and the values of this constitution. Now, in comparative Middle Eastern constitutionalism, as many of you well know, where the acid test has taken generally the form of Islamic law as in opposition to a source for the constitution, this novel formulation upholds our conception of religion as shield in ways that shift the terrain of the debate onto areas which may relieve the test from some of its acidity. This is not the end of the matter, however, as the law and religion complex in modern constitutionalism must be perceived increasingly in matter of 21st century constitutionalism on a far more difficult and elusive register. Actually, the absence of religion as religious affiliation in the Constitution. In other words, the problem is no longer whether Islam is state religion or not, but how collectivities which identify themselves on the basis of a religious affiliation can stand ignored by the constitutional setup. I had several occasions over the past years to discuss this vexing issue. We'll leave it at that. Now, the second acid test, federalism. Directly related to that issue of the place of sects in the constitutional setup of the countries concerned is the problem of sectarianism or communitarianism, as Indian constitutionalists call it. This is an issue which is also eminently federal. Federalism acts as an additional acid test. Of the three constitutions, only the Iraqi constitution mentions the word, and it may well be the most courageous. In Afghanistan, one will also not find the word federal in the constitution, but there is mention of peoples, tribes, and men in various articles. Giscard, the head of the convention, explains in his preface how the word communitarian came to replace the word federal in Article 1.1 of the Constitution, bringing an end to the heated debate of European federalists and European sovereigns. Now, a more federalist form of government than the European one is hard to conceive, and the refusal for the constituents to get drawn by the word indicates areas of irrationality getting into the government, where English and French national forms of the anti-federalist are pitted against mostly German and more recent Spanish adhesion to the concept as a perfectly acceptable one constitutionally. Even a perfunctory approach of EU, Iraqi, and Afghani constitution making shows that all these issues are very much alive. Indeed, the F word is as much a hot potato in Europe as it is in Afghanistan or Iraq, and federalism could indeed represent a line of approach which brings together the inchoate world of 21st century constitutionalism. It might have been wise for the constituents to have finally avoided the word in the refounding text. They knew they were all practicing federalism, like Molière's characters speaking prose without knowing it. Now, I'll leave the issue of the presidency, because of the time, and come to the conclusion. The new federal international order, the religion and state complex in its proactive Renaissance religion in law dimension, the confusion in the tripartite separation of powers, especially with regard to leadership and presidential bent, here are a few problem areas which define the shape of things constitutional in the 21st century. Beyond the natural disparity in the respective traditions and conditions of emergence of our three constitutions, we should perhaps end by bringing up again the special form of internationalism which seems to mark 21st century constitutionalism. One needs to reflect in a world that no longer recognizes internal affairs in a country as a self-contained one on the mechanism which may ensure that domestic problems do not spill over regionally and internationally. Even more positively, the question of constitutions as model can no longer be avoided. The world after Europe, in the fashion adumbrated by the proximity policy, is a case in point, but there's little doubt that success in Afghanistan and or in Iraq will raise constitutional standards to affect an immense area reaching into India through Pakistan and Kashmir and across the Middle East. There is no harm here putting the matter into the prism of our Kantian bifurcation with the two formidable vantage points drawn from Kant's treatise on perpetual peace, its failure since 1795 and its continuous success, which compels us to rediscover it again at such key junctures in human history, from the French Atlantic Revolution to the collapse of the wall in 1989. The three constitutions just examined constitute, through their birth and potential projections beyond their borders, an attempt to include Kant's cosmopolitan law into their frame. This is halting and timid, but the pattern is there for the discerning, whether in terms of federalism for Iraq, a unique novelty in the Middle East and Europe, crimes of war as a constitutional category in Afghanistan, or transnational projections of the EU, both federal and international. I would like to conclude on yet another horizon which conjures up in converging ways 2 millennia apart, Aristotle and Paul Kahn. At its simplest, the issue is one of man, less so woman, and this in itself is telling, as a political animal. How can, at the end of our introductory quote, the entire effort of the international human rights movement is rooted in this vision of well-being. No one, in this view, should die or suffer for politics. One could read this in the most exciting acknowledgement of the preamble to the interim Iraqi constitution, where it says that the people of Iraq reject violence and coercion in all their forms, and particularly when used as instruments of governance. One can also hear it plainly in a more relative, but potentially more applicable utterance, interspersed in a manner which seems novel in constitution writing, in the repeated references throughout the Afghani text to the scourge of crimes against humanity. In both cases, societies which have been literally bled white through 3 decades of continuing horror are showing the way to others, even to Europe, where the constituents remain behind in terms of the crucial task of preventing crimes against humanity from remaining unpunished. This point to the meta-conclusion of our emerging patterns, which is the next horizon of constitutionalism. How can human beings structure their domestic and international world to make politics redundant? Depoliticization, or depoliticalization, as Paul has it, I would like to conclude, is the ultimate horizon of comparative constitutionalism, that moment in history when it matters little what politics and politicians say because they have become, by and large, irrelevant to the happiness of the citizens. But I'm afraid one needs to leave that for constitution making in the 22nd century. Thank you.
I know that a few of you need to go to class. We have a very short time for questions. Professor Mallet has given us a great deal of food for thought, a century's worth, really. And there is outside food for the body as well as for the mind. So we will repair to the reception in a few minutes, but let's see if there are 1 or 2 questions that Professor Mallet has graciously consented to entertain. Yes, sir.
David Litt, a diplomat in residence at Duke. The Afghans arguably have been very receptive to international assistance and help in their tribulations over the last couple of years. The Iraqis, understandably, have been resistant to international assistance of one kind or another. What would be your prediction in 2005 as Iraqis try to put together this new constitution? Will they be seeking help from other quarters in the Arab world, in the EU, or elsewhere, or will they try to do it themselves?
But there is a practical dimension and a theoretical one. Practically, of course, one of the main problems with the present constitution, however brave it may have been, is that it was not open to wide consultation, and that's always a very serious criticism of any such effort. The reality is that it was very difficult to open it up for consultation. Now, normally, it is the new parliament which is in charge of the constitution in Iraq, and it will be very interesting to see whether parliament will be able to conduct, first of all, to be elected in a way which transcends the violence that in Iraq now today, and 2, once it's more or less properly elected, whether they will be able to convene in a way that brings in as much as possible, at least the Iraqi citizenship, into the debate. Now, so it's an eminently practical problem to which it's very difficult to predict what's going to happen in Iraq in the coming months. On the theoretical level, it seems to me that the inclusion of federalism, as I tried to allude, is a very conscious effort by the Iraqis to be ahead in constitution making. and all Iraqis, as I think you well know, Mr. Litt, for having trailed that path for years when they were quarreling over the control of Kurdistan in 1996. Federalism is an issue which is important, and that's why I mentioned it, because it's obviously not an Islamic tradition issue. So my sense is that this boldness, this courage that was shown in including that text, which is now in a Security Council resolution, which helps it a little bit, is indicative of forms of internationalism that the Iraqis are prepared to accept. But the practical dimension will always be more important than the theoretical one, I'm afraid.
Any other questions? Yes.
Remarkably plausible comparison of such diverse constitutions as the European, Afghani constitution and the Iraqi constitution. And you've named the internationalism within those constitutions and the international influence on those constitutions, and describe that as a trend for constitutions in the 21st century. To what extent does that help us to step one level up, so to speak, and see that not only as a trend for national, or in the European case, supranational constitutions, but instead as a model for what some call world governance, or the constitutionalization of the law of the world? In other words, is this refined to nation-states' constitutions, or is it helpful also in global governance?
Well, that's a very interesting remark, because it does bring, I think, a further hidden commonality in what's happening now on the world stage, which is the coming together of international and comparative law. Now, the forms of this are very difficult to predict. There's going to be fits and starts, and the fact that the European Constitution is actually a treaty is indicative of this bizarre blurring of constitution making and treaty making in the 21st century. So my sense is that there is going to be a lot of convergence between these forms of classical national sovereignty projections and international instruments that get suffused in national contexts. But it will not be, I don't think it will be a conscious one. In other words, the strength, I think, and the continued strength of Kant's treatise is that it does not erase domestic law. And that concept of cosmopolitan law, which is different from both domestic law and from international law, which he knew well, is what would define, that's work in progress, which joins some of what I've done. But I think there's a huge amount of work on Kant's Treaty of Perpetual Peace, because it does give so much to understand the 21st century 200 years hence. It's quite remarkable. And to that extent, the name of the law that we're discerning now is one which Kant calls cosmopolitan, I think.
Jed, yes.
The ambition you identify is to make human beings immune to politics, or at least immune to politics in its sacrificial form. One might look at that ambition in at least three ways. Most darkly, as a kind of utopian mistake. That might be a Schmittian view. Second, as a kind of regulative ideal and constant, something we can't actually achieve perfectly, but to which we can approximate and perhaps approximate increasingly. And third, as an actually achievable ideal. I wonder your view as to which of those is the most productive attitude, and if it is either the second or the third, what view of how history has changed our circumstances to make the possibilities open to us through the operation of constitutions different from those that that past generations have faced, and opened up constraints that seem to have borne more heavily on them. in the dimension of reducing the power of sacrificial politics?
Well, I mean, you're pushing me into the 22nd century, which I try to avoid, difficult as it is to discern the present trends. I mean, I can see you've thought this through quite a lot already, but my general position is a reactive one, and that comes from the fact that I do not see necessarily people turning away from politics as a negative thing. It is generally perceived that there is a disaffection amongst the citizenry, and that the citizen is disaffected and does not go to elect or participate. I can see the problem with this, that disaffection is not good for the political arena. But I try to see beyond, and this is where this question, which is I think a very valid one, gets premised on, well, what is so remarkable achievement in politics that one needs to be involved in it in one's pursuit of happiness? And so you can see my hesitation on this. I'm still reacting to the dominant vision, which is if people don't vote, then there is a very serious problem with society. And I think it's true. This is also true, but it's true only because, unfortunately, politics does still affect the life of people in ways which is heavy, too heavy for my own taste. And so, this brings a lot of utopian, as you say, possibilities. I've always found it extraordinary that the closest convergence in political theory may have been that of Mrs. Thatcher and Karl Marx, since both want the state to withdraw from the life of the citizens.
I'm sorry. I wonder if I could ask you to carry on the conversation at the reception. But before we adjourn, I have a parochial, and before we wither away, I have a parochial remark to make. For students in my own constitutional design seminar, which is scheduled to meet in 11 and a half minutes, we'll start 10 or 12 minutes late so that you can go to the reception, or even 15 minutes late so that you can go to the reception and have a word with our speaker if you like, and get some sustenance to make it possible to survive the afternoon. In the meantime, let me thank our speaker for a truly stimulating, wonderful lecture.